mystery, ransom. These are not generally words one associates with linguistics, and yet it turns out there is a subfield of applied linguistics that might be related to them. Hi everybody, this is Patty from LinguaBiz, and we were talking about in this episode about forensic linguistics. Please stay with us.
Hello, everyone. Thank you, Pati, for that very suspenseful introduction. Uh, as Pati says, today we're going to be talking about forensic linguistics. So, for a lot of people, the word forensic evokes images of white coated scientists doing lab tests and stuff that you see on TV shows like CSI, Bones, or Dexter. I'm going to be honest, I personally not familiar with those shows, but they're very popular, yes. Although the term forensics is normally associated with criminal investigation, it's used more broadly to identify activity related to the law enforcement and justice systems. In this sense, forensic linguistics are those who study or interpret language used in the legal process from a crime scene to a courtroom, either in the pursuit of justice or for general or applied linguistic scholarship, according to Hall, Smith, and Wikeksono, 2017.
Forensic linguistics is a rapidly growing subfield of applied linguistics, and it is now a well-established field of linguistics. With its own professional organization, the International Association of Forensic Linguistics. The phrase forensic linguistics was first recorded in 1968 by Professor of Linguistics Jan Starbik, who was analyzing the language in a set of legal statements. Equally important, forensic linguistic John Olson defined this discipline as, and I'm going to quote this author, the interface between languages, crime, law, where law includes law enforcement, judicial matters, legislations, disputes or proceedings in law, and even disputes which only potentially involve some infraction of the law or some necessity to seek legal remedy.
Thank you. Yes, and as we said before, in broader terms, forensic linguistics is the study of language in legal and investigative settings, according to Schmidt and Rogers, 2020. So we can categorize forensic linguistics into three overlapping areas, according to several authors, including Coulthard, Johnson in 2010, Perkins and Grant, 2013, Oxberg et al., 2016. So first we have investigative forensic linguistics. This includes comparative authorship analysis, social linguistic profiling, determining disputed meaning, analyzing disputed interactions, trademark, copyright infringement, and plagiarism, etc. Number two, we have the study of the written language of law. This includes readability, comprehensibility of legal language, ambiguity in legal language, interpreting legislation, issues in legal translation, and language policy. Number three, the study of communication in the legal process. So this includes police interviewing techniques, courtroom discourse, vulnerable victims, witnesses, what is called legal lay communication, court interpreting, and we will discuss these areas here broadly.
Now that we have given this theoretical basis, let's address some of the questions that forensic linguistics arises. The 18th century English philosopher and legal commentator Jeremy Bentham defined the law as an ensemble of signs. In more recent times, jurists have followed linguistics from the fields of semantics and pragmatics in question this. Bettman implies that the law is the linguistic instrument through which conduct is prescribed or proscribed, rather than the standard of conduct itself. Essentially, What's at stake in this argument is the difference between what is said, the linguistic instrument, and what is mean, the standard of conduct, between linguistic form and linguistic meaning. In other words, it is the law what it says or what it means. Mm? These questions gives rise to others. To what extent do the two fail to coincide?
Well, I think this is a question that has different positions. Usually, both sides are used together to talk about justice or make justice when they are used in the law field. And they are not referred as opposites only when we discuss or try to understand the differences, for example, in this case. And they are referred as the letter of the law and the spirit of the law. The letter of the law refers to the literal reading of the words of the law, whereas the spirit of the law means the intent or the meaning behind the law. And I have this one clear and famous example. That is what happened in The Merchant of Venice, written by Shakespeare. William Shakespeare wrote numerous plays and stories where he included some portion or included this spirit of the law versus the letter of the law as one of the main points of the plot. And in The Merchant of Venice, he introduces the quibble as a plot device to both save the spirit and the letter of the law. In this particular story, the moneylender is named Shylock, and he has made an agreement with Antonio that if he cannot repay a loan, he will have to, Shylock will have a pound of flesh from Antonio. And when the debt is not repaid in time, this other character, Portia, first pleads for mercy, but when Shylock refuses, she finally saves Antonio by pointing out that Shylock's agreement with Antonio never mentioned. So, therefore, Shylock can have a pound of flesh from Antonio only if he sheds not blood. No. Um, so I think this example is obviously fictional and is very dramatic, but we can see clearly how the differences or the difference between what the words of the agreement said and what it was the difference in the meaning with what was behind those words, and how this difference in meaning was used to save Antonio from a tragic situation. So, as I mentioned, it's a fictional example, but I think it really helps us to understand the difference between both concepts of what is written in the law and what it means.
Thank you, Alondra. Interesting comment. Then I have another question. Can justice be said to be done when the law is expressed but not understood? Somebody has an idea on this?
Well, here is where we talk about semantics and pragmatics, guys, which both are related to the way meaning is derived from language. But semantics, remember, studies the meaning that words and certain combinations of words hold for both the speaker and listener. While pragmatics deals with how the context in which words are used can dictate their true meaning at that particular time. And while all this brings to my mind different cases of people at court who have been judged or declared guilty, let's say, of different crimes just because they do not speak the language they are using at court. And I don't know, after some time, they are just found innocent. So I'm thinking about immigrants, for example, in the United States, or even indigenous people here in Mexico. I think we all know, have heard about those different cases.
Yes, Claudia, thank you. That's a good example. And what comes to mind for me is you see these lawyers and how they interact in the court of law. And at the end of the day, it's really about how they express themselves and if they can convince the jury of something. So I think that also has a lot to do with it. And yeah, there's many different factors. So yeah, these types of questions about the study of written language law can lead to all kinds of discussions, right? With different responses and yeah, different elements involved. So now let's talk about the area of investigative forensic linguistics. So in this area, we require the analysis of documents, such as ransom letters in kidnapping cases, threats or warnings about intended violence, such as a terrorist attack, suicide notes, wills, and cases of forgery. So in cases like these, forensic linguistics, they might be called in to compare the document with one or more known authorship, right? To take a look at it and compare to see if there's any similarities. So let's say in the case of a ransom note, a bomb threat, or the work of a forensic document examiner, that is crucial, not only in these court hearings or court proceedings where language data is presented as evidence of guilt or innocence, but also in the apprehension of suspects in the first place. So as we can see, this can help prevent further crimes, avoid false accusations of innocent people, and possibly saving lives.
Yes, this is possible with quantitative techniques and statistical measures from discourse analysis and corpus linguistics to provide evidence of authorship. One method is to analyze the documents in question and isolate groups of distinctive linguistic variables which appear to co-occur so that documents containing these elements are identified as likely to be authored by the same person, and documents that don't exhibit them are likely to be written by someone else. The linguistic variables analyzed might include the use of rare or unusual words or collocations, a variation in spelling and punctuations, particular syntactic structure or degree or subordination, and other idiosyncrasies of expression, including recurrence and or types of metaphorical devices.
Yes, thank you very much, Pati. And there's also an example here of the famous case of the Unabomber. So there was a big break that came when the FBI agreed to the Unabomber's demand to be given a public voice. So this is in the hopes that someone would recognize something about him or his words and be able to provide a lead. The New York Times and the Washington Post jointly published, it was a 35,000 word manifesto entitled Industrial Society and Its Future. So many leads came in from the public, but it was Linda Patrick, who was actually his sister-in-law, who put two and two together and identified him. So Ted Kaczynski was her brother-in-law. She convinced her husband, David Kaczynski, to review the published manifesto, and he was the one who immediately recognized these unique phrases and idioms, these oddly familiar ideas that were used by his brothers, such as the unusual term cool-headed logicians.
Imagine that. I mean, identifying identifying such features, identifying your brother, for example, the common sense linguistic intuition that led David Kaczynski to identify his brother as the Unabomber through the written word was the spark, but needed to be reinforced by more rigorous methods. The linguistic analysis was done by one of the FBI profiles. Guess what? Working on the case, James Fitzgerald, who at the time was not a forensic linguistics. So you might ask, why did this happen? Well, now with access to Ted Kaczynski's letters and papers provided by his family, a closer comparison between Kaczynski's language use and the Unabombers could be done. Does someone knows how was this done? I mean, it's pretty interesting, but does anyone knows?
Yes, I can tell a little bit more about this. As already Patty and Carlos mentioned, uh, there was a comparison between languages uses. And so what the FBI used was a simple computational method looking at word frequencies, spelling variants, and to build up linguistic profile to compare and match up the authors. For example, they looked for similarities, included both authors using analyze S with an S, spelled with an S, for analyze spelled with a Z, or license with a Z instead of a license with an S. So Fitzgerald identified a weird version of the common idiom, you can't have your cake and eat it too. Both Kaczynski and the Unabomber inverted it into you can't eat your cake and have it too. There were also many other similarities of content, style, and expression between Ted Kaczynski's known work and that of the Unabomber's manifesto. So, in fact, this agent Fitzgerald says that Unabomber's writings were and I quote, pivotal factor in cracking the case. So we can say Fitzgerald found Kaczynski's linguistic fingerprint.
Exactly. Language as a fingerprint. It has a symbolic meaning in the modern forensic linguistic. And as far as I remember, even though the term linguistic fingerprint has been proposed quite recently, actually, and has been a reason for a debate in linguistic circles, it states that each human being is using language differently in its own unique way.
Yes, thank you, Patty. Well, I think I have noticed this actually on the weekend that I have a very specific language when I write. For example, I use a lot of transition words. For example, however, therefore, moreover, and I use phrases like not only this, but also this. And it's mostly on my writing. Like I don't use this on my spoken form, but usually when I do write, I write like that. And also analyzing my language, I notice on WhatsApp, that is one of our social medias that we use a lot, that we can just tell a way, like in a way, about a person because of the stickers they use, the emojis, the phrases, the words. And I can usually tell when one of my friends is speaking, well, is writing to me in another friend's phone, just because of the way he uses all their punctuations, the words, uh, the emojis and stickers, their reactions, etc. So I think it's pretty interesting to see how everyone has a unique and specific linguistic fingerprint.
Yes, thank you, Natalia, for that contribution. I just wanted to add, you can definitely tell, like for me, for instance, I noticed that I use certain words and I repeat them. So after a while, you start to notice that kind of stuff, and you think, wow, that's kind of boring, right? We should maybe learn new words and new vocabulary. So I think well, obviously reading helps a lot in that case. So just an observation. And another thing is that we mentioned that forensic linguistics uh, call on expert witnesses in court to provide linguistic analysis of legal documents. Right, this can be in the form of oral and documentary evidence. So we have to include emojis. Yes, emojis. They they are expressions. They can help identify authors based on the language that are used in a document or a statement. They can also provide legal interpretation or translation in a courtroom. So these emojis used evidentially as a language in communication have posed new challenges for courts to adopt them as evidence beyond the traditional mode of speech and communication, and to interpret them appropriately, especially their aggressive side of meaning. This is according to Chang, Sun, and Lee, 2020. Has anyone else heard of something related to this before?
Yes, I have heard some examples in that, Carlos. Well, for instance, in France in 2016, a man was convicted of threatening his ex-girlfriend. and even he was sentenced to 3 months in prison. These charges were brought based on the text message in which this person sent to her ex-girlfriend again. He sent an emoji. So the court held that the emoji translated to, and I quote, threat in the form of an image. And this is not something new nor exclusive. Sometimes in the US, what I have also read is that emojis have helped people to contractual obligations in court. For example, some courts in the US have interpreted the thumbs up, fist bump, or handshake, even glasses, emojis as constituting an agreement or an intention to enter into a contractual agreement. That's amazing.
Yes, Karen, I agree with you. And one of the big issues that